Welcome to the latest episode of Risk Settlements Podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar on the latest trends and developments in the world of class action and commercial litigation. I'm your host, Kevin Skrzysowski with the litigation consulting firm Risk Settlements, and today we'll be discussing some very interesting trends and developments in food and beverage law. I'm pleased to welcome not just one, but two guests today, Sascha Henry and Chris Van Gundy, who are both partners at the law firm of Sheppard Mullin and leaders of the firm's business trial group and food and beverage industry team. Good morning, Sascha and Chris, and thank you very much for joining me this morning.
Good morning, Kevin. Thanks for having us.
Thank you, Kevin. Good morning.
So I know that both of you have extensive experience defending food and beverage clients and a wide array of litigation, including class action litigation. Perhaps the best way to start would be to have both of you discuss your careers at Sheppard Mullin and what your primary area of specialization is.
Sure. So I'll start and then turn it over to Chris. I've been at Sheppard Mullin. It'll be 25 years in September. So I've spent my entire post-law school career at this firm. And for the first, I would say, 14 years of my time here, I spent it doing a variety of business litigation disputes and class actions. And then within the last 11 years, really have honed in on consumer products and specifically class actions in the food and beverage space. And right now, my focus is about 90% on food and beverage companies, where I litigate not just class actions, but also contract disputes and also trade secret issues that have been coming up.
Very interesting. You, Chris?
Yes, I've been a general commercial litigator based in San Francisco for the past, I'm going to have to admit, 32 years. It's flown by. And in 2009, I actually was in Los Angeles for 5 years. I started the litigation department at the Roll Group of companies that included Palm Wonderful and Fiji Water and Wonderful Pistachios. And that was a wonderful experience. Even as in-house counsel, we litigated cases to the jury. Of course, there was regulatory work, and it was all about food at the end of the day. And that's where I first learned the term food lawyer, and I discovered I was going to have this career in food law. And ever since then, so 2009, I've been focusing my practice not only on litigation for food companies, but also all of the regulatory work, the label compliance and any other counseling issue food companies might need. And I still do non-food litigation, but as some of our listeners may know, there's many different class actions now involving food companies. It's unfortunately turned into a big industry, and I also have been defending class actions. I met Sascha around 2014. She had this idea for a food law conference, and we were at different firms. So we were conference partners for 5 years before we were law partners. And it was a real pleasure to hop over to Sheppard Mullin and join this group that Sascha built and still fearlessly leads to this day. And that was in 2019.
That's fantastic. And I'm glad that even the work time flies when you're having wonderful fun. So, but of course, with your experience comes opportunity, and the opportunities to showcase your expertise and your leadership really across the entire industry. And you had mentioned the conference. I had actually reached out, or my colleague had reached out to you a few weeks ago because I noticed that you are co-chairing CLE International's 6th annual food law conference. So have you both been involved since the inception?
Yes, we have. At the time, Chris was chairing a state bar food committee, and I reached out to him and said, what do you think about putting on a conference just on food law? And where I saw it really having appeal for folks is not just on the issues that I was dealing with, which were food class actions, but a more broader based food law introduction. Not all regulatory issues, not all class actions, but a much broader viewpoint. And so Chris and I co-chaired it in 2016. I think our first one was in Washington, D.C. And we've worked really hard every year to get a broad-based faculty experts in their field. That's where we put our priority. And we try to engage folks not just in the food industry or law firms or defense bar, but plaintiff side, academia, non-governmental organizations, and so forth, to really bring a lot of voices to the conference.
That's great. So it sounds like this is a conference, this isn't just defense sided. This is really for everybody. And it sounds like you've put together a real veritable who's who of defense, plaintiffs, in-house, regulators, and academia. So I think, I'm looking forward to it because it's a huge part of our business. And it sounds like we're going to be hearing some fresh perspectives from all sides of the aisles. Now, Sascha, it looks like you're going to be leading a discussion on current trends and issues facing food companies. Now, I know that in our business, when we're working with defense counsel and their clients to structure and potentially ensure class action settlements, even during COVID, we have seen a real increase in the number of putative class actions that have been filed against food and beverage manufacturers. What are some of the hottest topics that you're going to be addressing during your session?
So thank you. We have a general counsel panel, and that will be addressing some of these current issues. And I don't know quite yet what our panelists are going to say. And I would encourage folks to attend the conference. The general counsel panel typically is one of our best received panels, because we pose questions to our general counsels about what are the issues that they're seeing, what's on their mind, what are their concerns, what are the challenges that they have been facing. And so, as outside counsel and someone that's in class actions, we often see new trends in class action complaints and what the hot topic is there. But this is the opportunity for the food and beverage general counsels to identify what's on their minds and what did they see turning around the corner. So it's a very exciting panel.
And I think that's incredibly smart. Having worked with multiple general counsel and even had some on panels, they're always interested in retaining the best legal talent, but they'll also say it's not just retaining the best legal talent that know the law, but that understand our business and that understand our industry as well. So I'm looking forward to that. It sounds like that will be a great experience. I did want to pick your brain while we're on the topic on some trends that I've been seeing. For example, everybody in the food industry knows that there have been hundreds of these flavoring cases that have been filed over the past couple of years, but I've seen a lot win on the motion to dismiss phase. I was just wondering, what do you think the new direction will be in this breed of cases, or do you think there's going to be a new flavor of the day?
Well, I think that might have been a pun on flavor of the day. So that's a good one. We love to work in any food-related puns we can into the conference.
It was dying breed and flavor of the day. I think I worked in two in one sentence. So
Nicely done. So we saw a huge spike in natural claims. We saw, I think that started Chris, in 2011, 2010. And that lasted quite a while. And occasionally we even see some natural lawsuits being filed. You're right. The number of flavoring lawsuits has skyrocketed. They started, in New York and California, but they are in Missouri, Illinois, and Florida. Mm-hmm. And they aren't just vanilla. They've gone to all sorts of different flavors. But I think also what we're seeing is any claim that's on the front of the label, we're seeing the plaintiff's bar testing it. So as companies are becoming more mindful about sustainability, socioeconomic issues, and mentioning those on the front of label, we are seeing plaintiffs test those claims in the form of a class action. And so I think it might be too simple to say, but I'll say it anyway, which is the trend is what happens to be a popular front of pack claim. So, and right now we're seeing it, there were flavorings, but I think what we're seeing is more headed to socioeconomic, environmental type claims is what we're seeing get named also in these lawsuits.
It's funny you mentioned that. That was going to be my follow-up question was, are the new all natural cases the environmentally friendly and the green claims, and questioning whether a product is really recyclable or non-toxic? That's the new all natural.
I think the new all natural is just what happens to be a claim on the front of the pack. So that's how I perceive it. And that's how I think about it in terms of advising clients. What is on the front of your pack?
That being said, then how much time do you spend working with your clients, either when they're A, developing labels, B, changing labels, versus C, defending active litigation?
Well, Chris, you should answer this one too, because I think our practices are a little bit different. I love to be involved at the development of a label. I love being involved in that stage, but that varies by client. And a lot of times I have been hired only when the litigation has been hit and that they haven't had California counsel or food counsel involved in the development of a label. But I do really enjoy that process. Chris, maybe you can speak to your practice there.
Yep. Sascha and I actually will frequently work on regulatory and label compliance claims together. It may come to me, and then, of course, I'll go through the traditional advice of the 21 CFR to make sure that everything is compliant. But I think kind of our unique space in this area is that we do have regulatory counsel, for example, myself and others in California and in DC. Many of these practitioners are just in DC. And there is this California twist, I think, is important because of all the litigation here. The cases we were just reviewing with Sascha, many of them are not only in California, but in my backyard of San Francisco. And so when we're giving this labeling advice, we have to have an eye to the litigation. And one of the principles that was developed through the litigation we had at Palm Wonderful was even if you comply with all the regulations, your label could still be sued for being mislabeling. And vice versa, just because you don't technically comply with all the regulations doesn't make your label misleading either. So when giving regulatory advice, we really have to have an eye towards this litigation that's been grinding on for 10 years, and it's developed a life of its own, just like employment law or securities law. And in that area, I'm fortunate to have Sascha, and I'll connect with her on many label issues to see if she's aware of trends or has ideas to how to try to make these labels waterproof. There is no waterproof boat. There is no waterproof label. You just try your best to make sure that the client gets to where they want to go on the label and they're as protected as much as they can. Where I think Sascha and I are both amazed at how plaintiffs' counsel just seem to come up with new claims every year. It's sort of like, what's the new one this year?
I know I was speaking with some in-house counsel at the last conference I went to, which was Consumer Brands about 2 years ago, when we were at cocktail hour joking about how eventually there's just going to be white packaging with black letters that says milk, cereal. Because no matter how hard you try, it seems like those plaintiffs' lawyers in their crafty way to try and turn a profit will think of another cause of action to file against one of the food and beverage manufacturers. It is interesting that it's constantly developing.
And don't forget warnings. There's been some litigation in San Francisco involving Prop 65, as some of our listeners will know. And warning about we have to eat, but warning if you eat this, something might bad happen. So
it really is incredible. So, Chris, it looks like you're leading a panel on health-related claims, recalls, and COVID. Now, I know that in terms of health-related claims, we've seen a lot of interesting lawsuits being filed over the past couple of months, ranging from everything from cinnamon-flavored cereal to whole grain crackers to the amount of vitamin C that's in juice beverages. What are some of the hot topics that you think you're going to be covering in your session?
Well, we're going to have a speaker actually from my former law firm who's been developing a practice involving substantiation and health-related claims and healthy claims. And I actually have a case too, so I'll probably get a word in edgewise as well about healthy litigation. But we're all familiar with food claims that if you eat this certain oat bran, that studies have shown that it could reduce the risk of heart disease. Those are health claims. But we've also seen in litigation healthy claims that food companies allegedly mislead their consumers even if they don't use the word healthy, because they give the impression that their food product is healthy or will contribute to health. And so not only is there still a lot of regulatory label compliance work in that regard, as there has been for years, but now that litigation is picking up as well. And that kind of shades into substantiation, and that's kind of a black box for us lawyers, because as many listeners know, to make any claim under the FTC false or misleading standards, you have to have prior substantiation. You have to have something in your file before you make the claim that says your claim is justified by competent, reliable scientific evidence. And we don't really maintain those files or often build those files. So we wanted to have this seminar, this little panel, talk about what types of substantiation do you need in your file to kind of bridge that gap. And not only will we have an esteemed lawyer speaking from her perspective, but I've also invited one of the leading virologists with whom I've tried cases, who thinks like a lawyer, and she's going to explain from the science end what's really good science and what's really not. One of the legal standards, as I mentioned, is competent, reliable scientific evidence. It sounds magical. We all know what it means, but we really don't. And it's Dr. Leanne Jacobs from the University of North Carolina. She's going to speak about, from the science perspective. Also, she's been, as you might imagine, she's working a lot on COVID cases. And that's, of course, another panel or another conference and 3 days of conference, perhaps. But we couldn't resist having her talk a little bit about COVID, just to pull in the folks into our circus, our fun conference. But I think just to kind of anticipate maybe your next question, what we've all learned from COVID, I think, is that science matters. Science isn't perfect. It depends on the people. It doesn't purport to be perfect. And I think in law, just like in life, I think it's critically important for us to try to understand the science, its limits, where it can help, and take advantage of that. And we see this time and time again in advising on food law. I could go on, but that's the general drift.
No, I think that's a very important and critical rational connection of the science of COVID and tying it into the science of food law. You're right. I was going to ask you how important you thought really COVID was to the audience, because I have COVID fatigue, and I'm hoping optimistically that in the short term, we're all done speaking about it. But it has had profound effects on the legal industry. And I think you are spot on with tying science into science of food and beverage litigation as well. Going back to substantiation, you mentioned they have to have some type of science or some type of substantiation to bring the claim. On the defense side of things, when do you usually have an expert get involved in the litigation process, or when does your client want you to engage with an expert?
Right. Well, in terms of litigation, as soon as possible. It's not always easy to find the experts, and I think anyone who's practiced in this area for many years has a short list of people that they at least start with. I met Dr. Jacobs, for example, because I was involved in a case involving the poisoning of food with hepatitis A, specifically frozen berries. So I had to find someone who was the world's foremost authority on Hep A. And at the time, Dr. Jacobs was one of the leading people dealing with Hep A issues. Of course, now COVID has just wiped that all away, and she's been focusing on COVID ever since then. So I think early in the process, an expert can help you get a better understanding of the issues from a science perspective that you then craft your legal arguments around. Because I do think in evaluating cases, parties consider the expert evidence, and I think juries listen to it as well. And so I always like to work backwards. The gold standard is, what would a jury think? And if you have experts like Dr. Jacobs who can explain difficult concepts pretty handily, then work your way backward from the jury to the very beginning of the case.
Oh, understood. Thank you. That's a great explanation. Definitely. So to both of you, sounds like the conference is going to be packed with a lot of very exciting and innovative discussions around the hottest trends that are impacting everyone today. Moving our focus to more of like a litigation and settlement strategy. Let's say your client is on the receiving end of a class action complaint, what criteria do you employ when assessing whether or not a motion to dismiss is worthwhile and worth the expense to the client? Because in some of my previous podcasts, I've had some defense counsel say they tend to shy away from it because it gives the other party a chance to simply amend and they put their cards on the table. It sounds like perhaps in this particular industry, the mindset might be different. So what are those criteria that you employ?
There are so many factors, Kevin, that go into whether to bring a motion to dismiss. A lot of it depends on just how the issues are set up in the complaint to begin with. That's where we start. The other thing is, I would be remiss in not mentioning there's a practical aspect to think of here too, right? And a lot of times in analyzing whether to bring a motion to dismiss, I will delve into what are the sales that are at issue for this particular product. And I oftentimes will engage in informal settlement discussions before I even start drafting a motion to dismiss. If it is a low sales product, or perhaps it's a label that just hit the market, there might be an opportunity for a resolution that really gives our client the best result rather than spending the money on a motion to dismiss. The other factors that go into whether I file a motion to dismiss is what court we're in and who are judges. We spend a lot of our time in crafting our strategies in really understanding what our judge has seen before in terms of his or her own docket. Have there been food cases there before? How well versed is the judge in FDA regulations? And then, sometimes we'll do a motion to dismiss that's pretty narrow, right? The point you made about having a motion to dismiss, which gives the other side an opportunity to clean up their pleading and amend it and make it better, that's a good one. But sometimes we bring a motion to dismiss just on, say, for example, striking the injunctive relief, right? Because they haven't met that pleading. Sometimes the motion will be aimed at the class definition, depending on the case law in that particular jurisdiction, because sometimes that narrows it. I've brought motions to dismiss on others where the complaint has thrown in 50 states' laws, but only one plaintiff, just to narrow the scope of what we're looking at. So there are a variety of different factors that go into a motion to dismiss. And then the last one for me also is, is this the only time that I might see the judge before class certification is decided? And more our federal judges rule even on motions to dismiss on the pleadings. But our federal judges are so busy and they have such a heavy docket that a lot of times the first time we see them live to talk about our case is on a motion for class certification. So sometimes that comes into my thinking too about whether or not we'll file a motion to dismiss. Chris, you probably have a different approach than I do.
Those are all great points, Sascha. And I would only add that, and looking on my experience, more often than not, I recommend a motion to dismiss. And that's because, I'm working mainly in food law, and the law is so uncertain. It would have to be a case where if it's a natural claim and it happens to have been litigated heavily, then I could predict to the client, with this judge and with this case law, it's really not worth the time. But that doesn't seem to happen that often. It seems that the plaintiff's counsel are always scoping out new areas. Also, I would say that I really like your point about if other factors line up, this is also an opportunity to really have an interaction with the judge and see how she or he deals with your claims, your descriptions, that sort of thing. And so I think that's a valuable insight. And I've been telling clients more and more frequently over the years, this food court is going to go on indefinitely unless we start to have more litigation over it and develop more law, go to trial, fight these claims. At the end of the day, juries don't like these misleading food law claims. Jurors are smart. Certainly together, they're very smart. And they figured out right away that we have lots of regulation, lots of food information. It depends on the person, and they reject these claims at trial. So there's that little fight factor that I also work into my analysis, saying maybe we never want to file a motion that we don't think we're going to win, of course, but if it's on the border, maybe it's worth the fight. And I'll say candidly, sometimes your result depends on the judge you get.
That's interesting. So it sounds like there are a vast number of legal issues that go into deciding whether or not you file, leaning towards normally filing. But to your point about if the sales are low or the sales are high, or if it's a new product or an established product, that you're not only taking into consideration the vast legal ramifications for your client, but what the financial ramifications could be, the business ramifications, public relation, how relationships play a part, and what trial outcomes could potentially look like. So it really looks like it's a very holistic approach that you take. We're running out of time here, so let me ask one final question. Any other factors that would drive a plaintiff to settle earlier in the case rather than later in the case? And what would those criteria, those inflection points be?
I'll go first, and then Sascha can correct everything I say.
Hardly.
Yeah. Well, I mean, there's going to be the traditional analysis in these cases, like in any other case. But I think particularly in food law, the plaintiffs' counsel have taken advantage of the fact that we don't have a jury record. There are very few jury verdicts to pull to see what their claims are really worth. So one technique I like to use, and I've alluded to it before, is I come to them and I say, we all try to be candid in a settlement talk, right? Because you want to own your facts that aren't favorable. But I say, here's where we are, and we believe in our claim for this reason. And moreover, we're going to fight it. And we're trial lawyers. If necessary, we'll go to trial. We'll always talk settlement. There's independent value in helping the client understand what's at stake. And we learn in settlement how to make our cases better. But at the end of the day, Sascha and I both have extensive trial experience. And we're not the defense lawyers looking to cut a quick deal because they're uncertain about going to trial. And I've seen several cases. I've litigated cases pretty hard after motion to dismiss, and I just keep hammering the message. Sure, you got a point. Let's find out what a jury has to say. Do you want to do that? We're going to go to the mat. And I've seen cases drop that way.
I think Chris is absolutely right on that. I think from the moment the case comes in the door, we look at it from the perspective of what does the client need here? What is a practical approach here? But we always develop the case to make it ready to go to trial. And that is the end outcome. And ultimately, the jury is our audience, right? So that's how we're looking in terms of developing the evidence and discovery, what we pursue from the plaintiffs, what kind of experts we retain, what we pursue from plaintiffs' experts in the development of this case. But Kevin, in terms of inflection points, I think that there are a couple of pivotal timeframes in the class action life cycle that are important to be mindful of if you're thinking about settlement. And one is the motion to dismiss stage. We see a lot of cases get dismissed at that stage before a hearing or as part of the hearing, and then there's no amended complaint filed. So that's obviously a very important timeframe for settlement discussions. And then there's also the point of before class certification is decided. And at that point, the plaintiff sees that it might not get certified. And that's a very different case for them to be talking about settlement. And versus if they lose class certification, there really is no more case for them to pursue. Right. So that's a very important one. And then, Chris and I have gone the distance on these cases, and there have been cases that have been certified, and we continue to get it ready for trial. And amazingly, in that process, evidence comes forward oftentimes that gives us a solid grounds for a motion to decertify the class. Mm-hmm. And that also can present an opportunity for a settlement discussion because, the decision to certify a class is always provisional, and it happens at different times in the life cycle of a case. But as you approach trial and really get to the brass tacks of what the evidence is that the jury will hear, sometimes the individual issues no longer are going to predominate, and you can show that to the judge very easily.
Well, I think that very interesting, and I think those are great and valuable insights. So I think that's about all the time that we have for today, Sascha and Chris. Before we go, if anybody would like to register for the Food Law Conference, is there a link or a website they can do so before the March 11th date?
Yes. So if you go to www.cle.com, you can see all of their conferences, and food law is right there at the top. And the full agenda is listed there, the faculty, as well as registration. And we should mention that it is virtual this year. All 5 others were in person, and we hope to return to person, but it looks like that's going to have to wait to 2023.
Understandable. And if anybody who listens to the podcast would like to get in touch with you directly to discuss some of the topics that we addressed here today, what would be the best way to get in contact with you?
I would say by email. I'm at shenry@sheppardmullin.com.
And cvangundy@sheppardmullin.com. I think email's the best way.
Wonderful. Well, again, it was really great having you as my guest. I thank you for sharing all of your insights with me and with our audience. I would also like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, Snitcher, or anywhere where you listen to your favorite podcasts. And if you would like to learn more about my company and our litigation and settlement risk transfer solutions that are available, including insurance solutions to transfer the settlement risk in food and beverage class action litigation, please visit the Risk Settlements website at www.risksettlements.com. We'll also have a recording of today's program under our podcast section and also on the Risk Settlements LinkedIn page as well. So until next time, thank you for listening.